According to the news from reporter Xiaowen Yang, published on the Fact Portal, as the legal dispute between the group NEWJEANS, NJZ, and ADOR is in full swing, there is an outlook that whether the tampering, preliminary contact before the expiration of the exclusive contract, suspicion raised by ADOR will be proven will determine their fate. At the hearing for the injunction application for preservation of the agency's status and prohibition of signing advertising contracts, etc., held at the 50th Civil Agreement Division, Chief Judge Kim Sang-hoon, of the Seoul Central District Court on the 7th, ADOR claimed that the tampering of former ADOR CEO Min Hee-jin played a major role in NEWJEANS' attempt to break the exclusive contract. ADOR's attorney said, former CEO Min Hee-jin actually planned to take NEWJEANS out and start an agency, and if you look at the KakaoTalk messages at the time, former CEO Min Hee-jin said that he could take NEWJEANS out and start a company. The defense attorney then argued, the file attribute information of the contract termination notice sent by NEWJEANS to ADOR shows the writer is Sejong and SNK, and NEWJEANS did not submit the materials themselves, but submitted materials written by former CEO Min Hee-jin. Sejong Law Firm was former CEO Min Hee-jin's legal representative at the time, and SNK is the English name of Sejong Law Firm's company. On the other hand, NEWJEANS' defense attorney argued, former CEO Min Hee-jin was the driving force behind NEWJEANS' unique success as a girl group, but ADOR kicked out former CEO Min Hee-jin without consulting NEWJEANS, and this is a serious breach of management obligations. He then pointed out, the essence of the case is that Hybe and ADOR discriminated against and excluded NEWJEANS, and attempted to replace and scrap it with another group. The court also asked questions about the possibility that former CEO Min Hee-jin was involved in NEWJEANS' independent activities. When the court asked, the performance is scheduled for March 21, but did NEWJEANS find a separate agency or planning company? NEWJEANS' attorney responded, we are not in a situation where we can sign a contract yet. When the court then asked who and how they signed the contract for the performance, NEWJEANS said, I understand that the organizers are preparing the necessary personnel, but the members are not aware of everything, and there is no planning company that is in charge of preparing the performance. In the legal community, it is predicted that the outcome of the injunction will vary depending on how much ADOR, who is responsible for proving the allegations of tampering between former CEO Min Hee-jin and NEWJEANS, can prove it. Attorney No Jong-yeon of the law firm said, if there is decisive evidence of tampering before the notice of termination of NEWJEANS' exclusive contract, the injunction will be disadvantageous to NEWJEANS. However, he said, for tampering to be acknowledged, it must be proven that NEWJEANS and former CEO Min actively colluded, and there must be an act that actually has legal or economic effects, such as a contract, and ADOR must prove it with physical evidence. Attorney Kim Tae-yeon of the Taeyeon law firm said, the materials submitted by ADOR so far do not seem to clearly prove NEWJEANS' suspicion of tampering, and predicted, since the injunction is a matter of urgency before the judgment of the main case, it will be judged by considering which side will suffer greater damage and how much influence it will have on third-party companies. The court received evidence from both sides for a week after the first hearing and concluded the hearing on March 14. The court is expected to make a decision soon, as NEWJEANS is about to perform.